Hi, welcome to Do-It-Yourself Law videos. Today we're going to cover how to file a Chapter 7 bankruptcy case in Colorado. Now before we begin, as always, I have to give a legal disclaimer that this video is not legal advice and nothing in it should be considered legal advice. This video only provides general information about how to file for Chapter 7 bankruptcy in Colorado. Every case is different and the information in this video may not apply to your case. This video is not and cannot be a substitute for consulting with a licensed attorney. Now that that's out of the way, let's begin. So first we're going to cover today who might use this information, how you find the forms that you'll need to file your case, how to fill out those forms, and how to get those forms filed with the court. So who might use this information? So you've probably done some research into Chapter 7 bankruptcy and you're ready to file but you're not sure how to begin. You need help finding the forms, and probably more than anything you need to make sure that you have all the proper forms together before you file with the court, because as you're going to see, there's a lot of information that you have to get together and a lot of information you have to put together in order to get a complete bankruptcy petition into the court. So finding the forms. There's sample forms available on my website, DIYLawVideos.com. There's a link to my website in the description if you're watching this on YouTube, or if you're watching this on my website, just scroll down below the video and you'll be able to find the forms that I use in this video right there on the website. You can also find a lot of these forms on the Colorado Bankruptcy Court's website. They have a self-help section that has a lot of great information, especially if you're going to go it alone. They also have information about clinics and how you might be able to get a little bit of help to make sure you do everything right. Lastly, Google's always a great resource for just about anything. Now, before you begin, there's a lot of information you want to try and gather. So first, get your income documentation for the past 6 months. That's pay stubs. If you have rental properties, get receipts that you have from that. If you get stock dividends, any sort of income that you have, you'll want to get your documentation together for that for the last 6 months, because that 6-month period is going to be really important, as we'll see here in just a little bit. You're also going to need to get the previous 2 years of tax returns. Pretty much every bankruptcy trustee is probably going to want to see them, certainly the most recently filed tax return. You need to get a list of your assets together. So that's all of your real estate as well as all of your personal property. So kind of just do an inventory through your house as well as get any of those real estate documents together. You need a list of all your debts. Get the list that you have together, run a credit report. You get one free credit report a year, or you can just go to one of the major websites, either Experian, TransUnion, or Equifax, and they can get you a credit report that will have all of your creditors on it. Also, if you're getting letters in the mail from any creditors, gather all those together to make sure that they're all included in the petition, because you don't want to leave anyone out, because you want to make sure you get a discharge of all of your debts. Next, before you begin, you should probably do your credit counseling course. Before you file a bankruptcy case, you are required to complete credit counseling. If you don't do the credit counseling, they won't let you in the door. So sometimes the credit counseling can also be a good idea of whether you should file, or maybe there's another alternative for you. So go ahead and do the class. Best way to find one, just Google bankruptcy credit counseling and you'll find probably 300 possible places that you can go do it. Shop around. The rates vary from place to place. Lastly, I have on my website, as well as on the Colorado Bankruptcy Court's website, they have a bankruptcy booklet that gives information for people about what the bankruptcy process is, what debts are discharged, how to complete the forms. Read through that booklet. It has a great deal of information that can help you through the process. All right, so let's talk about filling out the forms. So, as I said, this is a rather large project that you're going to be putting together. So I've got one large PDF document that has pretty much the whole bankruptcy packet for Colorado. They have this form on this packet on the Colorado Bankruptcy Court's website. So we're going to walk through how to fill this out. Keep in mind that this video is really, we're going to take kind of a, just a 30,000 foot look at this stuff. There's a lot of moving parts to a bankruptcy case, and we're not going to go into in-depth detail in every last little bit of it. I'll have separate videos on some of those things. For example, the means test, I'll create a separate video on how to fill that out. I'll create a separate video that also discusses the statement of financial affairs and maybe some of the individual schedules as well. So we're just going to kind of gloss through that, but at least give you an idea of how you're going to go about filling this out. So this first section is just the cover sheet. It's pretty basic and pretty straightforward. You're just going to fill in your name. If you got an attorney, they'll fill this out for you, but you're probably to check no attorney pro se. Next, you got the filing fee. So if you're paying the whole filing fee, check the box for the Chapter 7. That's what you're paying. Now, here's the next list of everything you're going to put together. This is everything we're going to cover in this video, and you'll check the boxes for everything that you have and everything you're submitting to the court. So we got quite a bit of things we're going to get together here, but don't worry, we'll get you through it, and it should hopefully go pretty easily. Obviously, these things for Chapter 11, Chapter 13 won't apply to you because we're discussing a Chapter 7 case today. Again, this box here is just for Chapter 11 debtors, so you don't need to pay any attention to that. So print your name, sign, and date. All right. They got an information here, so they're going to give you notice about emailing, especially if you're filing without an attorney. So they'll give you notice about how you're going to receive documents that are filed with the court. Now, this next one is the voluntary petition. This one as well, very straightforward. You're just putting in your basic information up here, check the box, put in Colorado. They'll give you a case number when you file it. If this is amended, you check that box, but since we're probably talking about doing this the first time, you'll leave that box blank. So just got your name. If you're filing a joint case with your spouse, you'll fill in their information in the column right next to yours. If you got any other names that you've used, so if you've changed your name as a part of a marriage or as part of a divorce, you'll need to include that in there. Or if you've had any other aliases that you've done business with creditors, you'll need to let that know. Sometimes even nicknames or something like that. Last 4 digits of your social security number, because this is going to be a public document, so don't want to put your whole social security number there. You do have to file a statement of social security number. That document though will be kept under seal with the court, so your social security number doesn't appear in full in any of the bankruptcy court documents. Again, if you have any business names that you've done, if you've been an employer, you'll include that there. Where you live, this is your address. The address box up above is your mailing address. That's the best place for you to get mail. Why you're choosing this district, so you have to have been in Colorado for the last 180 days. If you just moved here, you're probably going to need to file back in the state where you lived previously. Or if you have some other reason, there's other exceptions, and that's probably something you want to talk about with the lawyer. So next, you're going to tell the court what chapter you're choosing. It's Chapter 7 case is what we're talking about here. For most debtors, it's either Chapter 7 or Chapter 13. Chapter 12 is for family farmers and fishermen. Chapter 11, that's usually for businesses or people who have just huge amounts of assets that would disqualify them from Chapter 13. Next, how you're going to pay the filing fee. You're going to pay the whole $300 and change that you change it from time to time. Check this box. Now there's 2 other ways you can do it. You can pay it in installments, or you can request to have the entire fee waived. I'll cover in a separate video how to go about filing a motion to pay in installments, or how to request that you have your fee waived, because those are separate forms that you got to fill out. If you filed bankruptcy in the last 8 years, the court needs to know about it. This is very important if you filed a Chapter 7 case, because in a Chapter 7, if you received a discharge in the past 8 years, you are not eligible for another Chapter 7 discharge under the Bankruptcy Code. There could be exceptions to that. If you're not sure, consult with an attorney. If you're not sure when you filed your last bankruptcy, you're going to want to go get those forms together. If you did file bankruptcy previously, find out when you filed and if you received a discharge, because you'll need to let the court know about it, just because it'll affect how they handle your case and whether you might be eligible for a discharge. Again, if you have questions about this, or if you're not sure if you're eligible, that's something you definitely want to talk to a lawyer about. If you got any pending bankruptcy cases that affect you, so that could be a case filed separately by a spouse, or if you've got an affiliate or business partner who filed bankruptcy that's affecting creditors, you need to disclose that with the court so that way they can handle your case appropriately. Now, if you're renting, there are certain rights that a landlord might have in these bankruptcy cases, especially if they have a judgment for possession at the outset of the case. So you got to disclose that to the court, so the court can again handle your case appropriately. If you own your own business, you got to let the court know, because that changes some of the questions that they're going to ask you and some of the things you'll have to disclose, in particular with regard to business records. So if you have any property that poses a threat to the public health, you got to disclose that, but that usually doesn't apply to most people in Chapter 7. That's usually mostly for businesses that are going to have those issues. So you have to do the credit counseling. You have to do it within the last 180 days. If you didn't do it, they're probably not going to let you in the door unless one of these exceptions applies to you. Best thing to do is do the class. You can do it online usually, and you can have it done in about an hour or so. So there's no reason why you shouldn't be able to get this done pretty quickly, and you'll attach the certificate that they give you to your bankruptcy petition when you file it with the court. And you'll stick it in right after this page right here. There are certain exceptions to it, and if those apply to you, then you may be exempt from having to do that, but those are very, very rare, and in general, the court really wants you to do the credit counseling. They want a little information about your debts. So check these boxes, whatever applies to you. These are just estimates of what you have. These things can change. So if it turns out you have more creditors or more debts than you realize at the outside of this, you can always file an amended petition, but give your best guess and do your best good faith estimate as to what's there. You're going to sign and date right below there. And now you've got the petition filled out. next, you do have to sign this information. You have to be honest and truthful with the court. It's obvious, I think that goes without saying, but if you do lie or conceal assets or conceal things from the bankruptcy court, that could be considered perjury, and this form explains some of the possible consequences for it. And bankruptcy fraud is investigated by the FBI, and there are possible criminal and civil penalties for it. And you could also lose your discharge if you don't fully disclose everything to the bankruptcy court. These next forms are, well, the 101As are basically for if you have an eviction for judgment against you. So if you own your home, that's not going to apply, but if you're renting, you'll want to fill this out, in particular if there's a judgment against you for it, because that'll affect whether or not you can stay in your property, and it'll affect the rights of your landlord. All right, the statement of financial affairs. There's a lot of information the court's going to want from you here, and I'm going to buzz through this really quickly. So basically, I think a lot of this is very straightforward. It's just questions, are you married? What income have you had in the last few years? Disclose that. If you had those tax returns together, you're just going to put those numbers right into there. They'll want you to know what type of income you received other than income from employment. So, if you had stock dividends, if you had, your own small business, you'll need to disclose all of that. If you've had any other, if you've paid any creditors in the last 90 days, you'll have to disclose that. If you have, other assets, if you've had not Social Security, but a bank deposit box, you'll need to disclose assets like that. If you've had losses from gambling, losses due to fire, you need to disclose those things as well to the court in the statement of financial affairs. If you've been party to a lawsuit, for most debtors, this is usually if you've had a creditor suing you to do a collection action, if you've been in a foreclosure, if you've been going through an eviction. There's probably a court proceeding out there. You'll need to disclose that to the court, let them know the case number, give as much information as you have about that case. If you've had any other property possessed, you've had anything foreclosed on the last year, you need to disclose that because some of those transactions can be undone. If you've got any gifts of any significant value, either that you've given to someone or that you've received from someone, you have to disclose that to the court. And if you've made any contributions to charity, large contributions, you'll have to disclose that, because what the court's really looking for here is, are you trying to get rid of things? Are you trying to basically game the system to protect your assets to the benefit of certain people over your creditors? Because they want everyone treated fairly. The idea of bankruptcy is that everyone should be treated fairly once you're in the bankruptcy process. So let's skip down here because I think we've covered probably most of this information. And again, I'm going to create a separate video that goes into depth about each of these questions here. So take a look for that video if you have questions about this statement of financial affairs. But for the most part, the questions are very straightforward. There's no trick questions. You just need to be honest and forthright about all of it. And if you're not sure, go ahead and disclose it, or better yet, consult with an attorney and have an attorney give you an answer that suits your individual situation best, because there's so many moving parts to this, as you'll see as you go through it. So many questions that you probably can easily get overwhelmed with it. Once you get down to the bottom of it, you're going to sign it, date it, and print it out, and you've got your statement of financial affairs. Now the next thing, you've got a summary of some of your assets and liabilities. Basically what you're going to do is you go through schedules A and B and the rest of your schedules. These boxes will kind of fill them out. You'll just add up the totals from those as we're about to go through, and this is basically just whatever comes out of the calculator is all you're going to put into these boxes. But go through each and every single one of them and check those boxes as they apply to you. All right, let's go to Schedule A and B, your property. Schedule A is your real estate. So that's only if you own any actual physical real estate. So that's a house, a condo, any other land that you own. If you own a farm, you got to put that on there. That's the real estate. Schedule B is your personal property. That's pretty much everything else. So that's cars, household goods and furnishing, tools of your trade, artwork. There's a whole list of these things, and it's going to walk you through it and give all the information that you can for it. So for the cars, your make, your model, your year, the approximate mileage. If somebody else owns those cars, you need to put those, let that person know or disclose that to the court. So just give as much information as you can, or as much information as asked for in this. If you own any watercraft, if you own any aircraft, motorhomes, ATVs, you list those in a separate box and simply walk through all of this. Now, in terms of valuing these, think about present market value. It's not what you paid for it brand new, it's what you could get for it today if you liquidated it. So if you sold it on eBay, sold it on Craigslist, or you had a garage sale, what would you get for those things? So if you're not sure what an asset is worth, hop onto eBay, Craigslist, and take a look and see what similar things are going for, because that's the value that you're going to give it. So I think it pretty well walks you through all of this. So cash is physical cash. There's a separate box here for deposits of money, so that's checking and savings account. So you have to disclose what physical cash, so that's dollar bills and change that you have. Anything in the bank goes into number 17. So we're going to skip ahead here and we're going to go to Schedule C once we get past the businesses. One moment while it loads. All right, Schedule C is your property that you're claiming as exempt. Now there are bankruptcy exemptions, but in Colorado there are state exemptions, and the state exemptions are what are going to apply. And really this will be covered I'll cover this in a separate video, how you might want to go about filling this out, but odds are most of your assets are going to be exempt. So for example, for real estate, you get up to $60,000 of equity in your property is exempt. Up to $5,000 of equity in a vehicle is exempt. You get thousands of dollars for tools of your trade. You get $3,000 per person, per head of household, for household goods and furnishings. You get money for jewelry, you get money for artwork. There's a whole list of these categories and things you can go down in terms of claiming what is exempt. But again, the federal exemptions aren't what apply in this. It's the state of Colorado's exemptions under the Colorado revised statutes. And again, I'll put those in a separate video as to how to go through those. But basically, this schedule here walks you through it in a pretty straightforward way, how to claim each different category of your property as exempt or non-exempt. And you just basically think about each thing that you have listed there in Schedules A and B, and go into the Schedule C, list it there, check the box, and if you will look up the statute, the Colorado revised statute that applies to it, you're going to put it in right there. All right. So once we get to Schedule D, now we're talking about your creditors. So Schedule D is for creditors who have secured claims on your property. So an example of that is a mortgage or a loan on a car. So if you default on your mortgage payments, the bank can come and take your home. If you default on your car payments, the bank can come and take your car. That's a security interest. Those are the types of creditors you're going to list here. Now there's two other types of creditors, unsecured creditors, so that's like credit cards. Those are going to go under your Schedule F. Schedule E is going to be for people who have leases. So if you're leasing your car, that's not a security interest. That's not a secured creditor. That's going to go on to the next schedule, Schedule E. So again, you just walk through this, fill out each one of these boxes, give all the information, the name of the creditor, their address, the amount of the lien, and the value of the property, and you identify the property that the lien is being held, that's holding the lien. Now, Schedule E and F are creditors who have unsecured claims. So the unsecured claims are into two different categories. Excuse me, I think earlier I said Schedule E was going to be leases. That's actually going to be Schedule G. Schedule E and F, so there's two types. There's priority unsecured claims. So that's going to be taxes primarily. They're going to have priority over all of your other secured claims, and those may not be discharged depending on how they're treated. But again, that's a question that can vary from person to person and case to case. Consult with a lawyer about that. Now as you go into Schedule F, it's the same thing. You're just going to give all the information for it, the name and address of the creditor. You're going to list when the debt was incurred, the approximate amount of the debt, and you can kind of go through these boxes, if it's contingent, unliquidated, disputed. If you're not sure what it means, you don't have to check those boxes. You can amend it later, or better yet, talk to a lawyer about it. I mean, it's fairly straightforward. If you dispute the debt, check that it's disputed. If it's contingent, that means it's a debt that only occurs if something happens in the future that hasn't happened yet. So let's keep going through this, and let's get to the next set of schedules here. All right, so now you fill out this box here. This is just the total amount of all the claims, and just add these up, add up everything you've had in those prior boxes, and it goes into this right here. All right, Schedule D, executory contracts and unexpired leases. This is where you fill out your leases. So if you're renting your property, you're going to put that information in here. If you're renting your car, you're going to put that information in here as well. If you're renting any other property, if you're renting household goods for some reason, or you're renting lawn equipment, or you're renting equipment for sole proprietorship, that's your business, you'll want to include that information here as well. And you'll have the option later on to either reaffirm that debt or keep on the lease if you're current on those payments, or you may be able to void the lease. But again, that can be a complicated issue. If you have a lot of leases that you're worried about, definitely consult with a lawyer about it before you go into bankruptcy court yourself. Otherwise, you can just cause a lot of problems. Schedule H, co-debtors. So if you had someone co-sign a loan for you. If mom and dad co-signed a loan for your car, you have to give them notice of it as well, because your discharge will not apply to them, to your co-debtors. So they would still be on the hook for it, so they have to be notified of it, and they are going to be participants in this process as well. Now, Schedule I, your income. This is pretty straightforward. You probably already put in a lot of your income information in the Statement of Financial Affairs, so you're just going to go right through here, give your employer's information. Obviously, if you're not employed, you don't have any income, all this is going to be zeros. But then it just basically, you walk through the boxes and you just use your pay stubs, and you can create a monthly idea of what you bring home every month on average. So if you're not sure how to do it, just kind of do your best estimates, put your averages in, or really if you're not sure what counts as income, or you're not sure what some of these deductions are and where you'd put them, talk to a lawyer, because again, a lot of this information is complicated and a lawyer can help walk you through it. Your expenses, again, this is pretty straightforward, and they're going to walk you through exactly the types of expenses that people have. Real estate taxes, what you pay for your rent, what your homeowner's insurance is. If you've got HOA dues, what you pay for your utilities, what you pay for clothing, childcare. Obviously, these are things that you average out into what you spend in a month, not just what you spend once every 6 months or so. So if you buy clothes once every 6 months, whatever you spend, divide it by 6, and that's what you average out per month. Again, what they're really looking for here is what you average per month in this particular form. And the numbers pretty much just add up, and at the bottom line, it'll give you what your monthly income is, whether it's a positive or negative. If you've got any expected increase or decrease in your income, you're going to put that in this box right here. If you're anticipating a period of unemployment, or you just got a new job and you're going to be starting in a month or so, or in a few weeks, you'll explain that right there and let the court and let the trustee know about that. So if you have a separate household, so that's if basically you and your spouse have separated and they have a separate amount of income, give as much information as you have about it. If you don't have that information, you'll let the court know that you simply don't have that information. Again, that may be something you definitely want to consult with a lawyer about, because that can complicate things if you're married but separated, and how whether or not that person's income is going to be factored into your case. Now you got a sign saying that all the information that you just gave is true and accurate to the best of your knowledge and ability. You do that under penalty of perjury, so again, be honest and forthright with it. Now, you have a verification of creditor address mailing verification of creditor address mailing matrix. You're going to sign and date this, but you also have to create the matrix. Now, this varies exactly how they want you to do it, but as of the date of this video, the way the Colorado Bankruptcy Court wants you to do it is create something like this. In a notepad, they want you to create a list of your creditors, the name and their address, 3 spaces in between, then the next creditor goes in there, 3 spaces, and so on and so forth. I'll have this notepad, this sample matrix, up on my website for you to download to put in your information. You save this to a CD, and you'll take this into the court with you with the actual paperwork, and that's what the court uses to generate a mail. They're going to send out all the notices to all of your creditors, but you have to include that with your filing. Statement of military service. So if you are in the military service, you got to let the court know about that. Statement of your current monthly income. So this is the means test, is what you're going to fill out next. I will create a separate video about how to fill this out, but just again, you're going to go through your income and all the deductions right here, and you just follow the boxes step by step. Hopefully, if you're below the median income for the state of Colorado, you get down here to determine if the means test applies to you. If it doesn't, you're good. There's nothing else you need to do. If it does apply to you, then you continue on and you move on to the next part of it, which is the statement of exemption from presumption of abuse, where you have to prove that you don't have the means to pay for any of your debts. Again, this is a very complicated form, and one that I will create a separate video on how to fill out and how to go through it, because there's a lot of moving parts to it. But again, for the most part, it's pretty straightforward. Just follow the instructions, walk through each question, answer it honestly, and you should just get to a natural conclusion as to whether or not you qualify for Chapter 7. Because really what this is whether or not you qualify. In 2005, Congress amended the Bankruptcy Code and limited Chapter 7 to people who didn't have the means to pay back any of their debts. But if you have enough disposable income, or you're making enough money or too much money, they want you to help try and pay some of your debts back, and they might force you into a Chapter 13 plan instead of a Chapter 7. Again, if you're not sure about this, or you've got questions about it, this is something you really can sit down with a lawyer and have a lawyer help you out with, and that's where they can really make a big difference in your case in making sure that you qualify for the Chapter 7. And again, as you can see, this is a lengthy form, and we are almost through it. You sign that one, And if you had a bankruptcy petition preparer, they're going to fill this form out. If you did this yourself, you don't, then you're going to come to disclosure compensation of the bankruptcy petition preparer. Again, it only applies if you use that service. If you did it yourself, that wouldn't apply. Statement about your social security numbers. This is a form where you fill out your entire social security number. Make sure you put it in correctly. You don't want to put in the judge's social security number accidentally and make them file bankruptcy. That would be a nightmare. So just make sure all that information is correct. This form is kept under seal, so no one will see publicly your social security number, but they do want to verify that you are who you say you are. Your statement of intention. So this applies to the debts to your leases and your secured debts. So let's say you've got a car and you've got a loan on it and you owe money on it. If you intend to keep that car because you want to continue to afford it and you need the car to get to work or something, you'll say, hey, I'm going to keep this property, and check the appropriate box. And so you fill out with the creditor's name, the property, check the box for what you want to do, and whether or not you claim it as exempt. Now, on the other hand, if you can't afford your car anymore, even after the bankruptcy, you're underwater in it, you want to get rid of it, check the box that you're going to surrender it. And again, you can amend this form later on down the road, but this is letting your creditors and the courts know what you want to do. Because the other option is you can reaffirm it, and you can try and go through that process, and I'll have a separate video about the reaffirmation process and how to fill out those forms. But that's something that comes later after you've filed your case. And again, you do the same thing with your leases. This is Notice 342, so you have to fill this out and you have to go through this to make sure you've read this form, and you'll sign at the bottom saying that you've read it and you understand it. Read the important warnings, making sure you're being honest and trustworthy, and that you're doing everything above board with the court. This last form, this is just a caption form, and then you have to file this statement of under penalty of perjury concerning your payment advices. So basically, you have to say, I filed my payment advices. So what that means is basically pay stubs. So if you have documentation of your income for the last 60 days, they want you to file that with the court. You fill this form out saying, I was employed, I've attached the advices, and they're with the petition. If you don't have those for any reason, either because you weren't employed, you've lost them, or they've been destroyed, or your employer doesn't have them, or you can't get copies of them, or you're self-employed, check the appropriate box, and the court will probably inquire further about your income and making sure that everything that you've put in these petitions previously is accurate. So that pretty well gets us through how to fill out those forms. Obviously, the next step is you're going to file them with the court. Go to the Bankruptcy Court's website. Downtown Denver is where the main bankruptcy court is located. They also have an office in Colorado Springs and out in Grand Junction where you can file. If you're filing yourself, you're going to have to go into the court, bring all this paperwork with you. They also have a good self-help and pro se resource center there that can help you fill out these forms. They have some good software that can help you make the matrix if you're not sure how to do that. And if you go in there to file, the court clerks will make sure that you have all the proper documents that we've gone through here, and make sure that you're good to get into the court, pay the filing fee, and then you should be on your way. So thank you so much for watching. If you found this video helpful, please be sure to like it or subscribe to my channel. As I said, I'm going to have more videos that cover in more detail some of this, because I know that's a lot of information, and I know this is almost a 30-minute video, but really we have barely even scratched the surface of how to file a bankruptcy petition and some of the issues that can arise in these cases. But again, thank you so much for watching, and we'll see you next time.